here to discuss recent changes in discovery proceedings and FINRA customer arbitration hearings is Richard De Palma.
Thank you. My goodness, that sounds longer than it should. Hi, everybody. Good afternoon. I noticed as I was sitting out there listening to the other discussions that, we're going to talk about, where we are a year plus after the change in the discovery guide and in the lists. But if you view that subject as a circle and you listen to the other things that we talked about today, a lot of these circles, I think, are overlapping. And I wanted to make an observation, at least my observation of what I see. Where it overlaps, that center area between parallel proceeding issues and whether it's enforcement and FINRA arbitration or court issues and arbitration, in the middle, I think you could write the following statement. How hard are we going to hold on to mandatory arbitration? Is it suiting us any longer? How far will we or FINRA go to keep that in place? I think that's a discussion that could take much more than 20 minutes, and it's certainly something that came up during John's discussion in lunch. We were talking about appeals from arbitrations, and yet most of the people in the room wanted to talk about whether arbitration is still something that we want to go through. But it's a nice segue into what we're going to talk about, which is the new guide and the lists. Like all arbitration fora, FINRA rules provide for the exchange of discovery and information. And, the question is, where are we now compared to where we used to be? The code for, at least for, for both inter-industry and customer disputes says that you're supposed to really cooperate with each other to the fullest extent possible. And I'm confident all of you have felt this level of cooperation on a regular basis. I'm sure you're, at the holidays, you're just flooded with cards from your adversaries. There are things you can do. Now, back in the day, back before 99, we fought about all discovery issues. There was no list, and the idea at that time was to create a situation where there would be lists, and then that would reduce the fighting over discovery. Well, I think what ended up happening is the things that we used to fight about were now on the list, so you couldn't fight about them anymore. So we started fighting about whether they were going to get things that are off the list. And to some extent, the new list opens the door even further. And that was one of the concerns that there was about the new list as we went into the review process before it was revised. It's supposed to be, well, the SEC says and FINRA says, to promote easier, simpler discovery in customer arbitrations, and that as a result, it'll be cheaper and quicker. I don't think it's cheaper and quicker, and that goes to the point we were talking about earlier, but a lot of you were at SIFMA in Miami back in March, and if you remember, on the third day or on the last day in the morning, it was a panel discussion that involved, among other things, the new discovery process. And Linda Feinberg, who's the president of the arbitration group, actually asked a group of more than 100 people in the room, practitioners, I think there was only one claimant side guy in the room, who thinks it's simpler and easier under the new guidelines? And not a single person raised their hand. And she seemed generally surprised by that. I didn't expect her to be so puzzled by it, but I don't know how they thought that this was actually going to make things easier and simpler, but they keep saying it, and we'll all discuss whether that's true or not. My view is that it is not. A general overview of the changes. Everybody's been dealing with it for more than a year. It went from the 14 lists to 2, and although the number of lists have gone down dramatically, the categories of information that have to be produced, particularly by the firms, has increased. And so, going back to what I said earlier, I think, now the things that, Claimants Counsel is constantly trying to get under the 99 through 2011 lists and guides are now on the list. So now I think what we're going to experience going forward is an expansion in terms of things that are off the list that people are going to try and get in discovery. There are a number of things that are now added, and I won't go through them all. They're in the materials. But basically, things that firms or at least are presumed to be discoverable from firms are telephone logs, advertising materials. There was a lot of comment in the lead up to the this coming into effect over that term advertising material and how broad it could be construed. There was not a lot done to try and limit that in the rule that came out. Customer complaints filed against the associated persons assigned to the account at issue for the 3-year period. Disciplinary history, there's an expanded scope of documents with respect to that. Documents evidencing trading or investment strategies utilized or recommended in the account at issue, and compensation for transactions at issue. On that last one, it seems that unless we have a churning case, the compensation issue is sort of a red herring and certainly a problem for producing it sometimes. But it made its way into the rule nonetheless. There weren't too many changes on the other side, however, in terms of additional documents that we get from claimants. Research reports received from the firm, which presumably we have anyway, non-confidential settlement documents in civil actions, documents the claimant received related to the investments at issue, materials received by the claimant or obtained from any source relating to the transactions of the products, and correspondence related to the account at issue, and not just with respect to the firm. The problem that you experience is that a lot of claimants just don't have the information, and so you can expand categories to some extent, but it doesn't mean necessarily you're going to get more information out of them. One of the things in the run-up to this rule change was an announcement by FINRA that they were going to create a discovery task force. And in fact, they did. They did about 6 months after the time that this rule went into effect. And it's under the auspices of FINRA's National Arbitration Mediation Committee. I had an opportunity to learn some of the things that the task force has looked at. I mean, predominantly, the task force is given the role of looking at changes in the industry and advising on changes to the process, whether it be by rule change or by additional information given to arbitrators or education, to deal with things as products become more complicated or as products change over time. But the very first thing that the task force was asked to look at and did look at was the issue, which is hot on a lot of the circuits nowadays in the legal industry, e-discovery. One change to the rule was that electronic documents are now definitely termed documents in the way we look at it for production purposes. But FINRA didn't include any information to guide arbitrators on how to deal with e-discovery issues, which is significant when a lot of panels don't have lawyers. We have more public arbitrators, and they're not used to dealing with things. Even the lawyers sometimes that are on the panel who are not litigators have problems dealing with e-discovery issues. And so the task force has, over the last year, been looking at that issue. They've decided not to promote or ask for any additional rule changes. They have decided the way to deal with e-discovery is through more information to arbitrators and through education. And we'll see whether that's something that actually helps in terms of dealing with the electronic discovery issues. I mean, the big problem with electronic discovery is burden, especially for the firm side. And you'll deal a lot of times with claimants counsel who are not commercial litigators, and there's difficulties when you make a phone call and say, let's talk about the protocols for electronic discovery searches, and they don't know what you're talking about. Just give me everything that you've got. And as you all know, that can range in the hundreds of thousands of dollars in some cases. The other issue that the task force has looked at over the last year has been with respect to products cases. And again, they're not advocating any kind of rule change or additional work with respect to changes in the code or in the guide, but they're looking at giving more information to arbitrators in order to have them be better equipped to deal with the issue. Although, again, I think it was Tony that said one of the things that you can do is make sure that when you present your expert and you present them in person, especially to panel members who are not industry people, that you lay out exactly what you want them to derive from the information. Otherwise, you're gonna be rolling the dice. Okay, so have they attained any of the goals that they expected to, or at least announced that they were going to, at least in the year and change since the guide and the list went in effect? If the goal really was, if it really was to make it easier and cheaper and quicker, I think the answer is no. There has been an increase in discovery disputes. Although there's been a real focus on flexibility with arbitrators, and I actually do think, and we'll get to that in the next question, but I think arbitrators are being more flexible. As the list expanded and more is in, it does give rise to greater chance of successfully arguing, rational points with respect to exclusion of information that's unrelated to the claims. So I think in that sense, it certainly has had some assistance, but that's only because the amount of information that is covered by the list is greater now. I think we've increased the expense even in fighting over things that are on the list, and of course we'll always have a push from claims bar to get things that are not on the list, but that they think they really need. With respect to flexibility, I do think that it is the case that arbitrators are taking to heart the mandate to be more flexible. Not always. One place where I think they have not really moved forward at all is in terms of cost shifting with respect especially to electronic discovery, but where the burden is heavy and they insist on getting particular bits of information that you can argue are really not relevant to the claims in the proceeding, arbitrators should be better able to shift the cost if plaintiff's counsel continues to you really demand things that are outside the scope of what's really needed and desirable. Just a couple of practice tips. You've heard a lot of them throughout the day. I've crossed a bunch off the list that other people have already sort of laid out, but a few things that I would just add to what's already been said. I think that it really serves your interest to look at the new lists and look at the claims carefully early in the process and really try to map out what you think you reasonably need to produce and what you think you're willing to fight on because the cost is or the burden is too much. I will always pick up the phone and call claimants counsel and see whether we can stipulate to either working outside the lists or to exclude whole categories. And we've had some success with that. I mean, you don't always get them to agree, but if you can cut some of the stuff down in advance, that's fine. now that motions to dismiss are extremely limited, to the extent you used to use those to pre-argue the case, you certainly can do that a little more effectively currently in the context of motion practice over discovery. The problem with that is that sometimes it's only the chair that actually decides it, so you're not getting to the whole panel. But it's certainly a tool to use. And, I sort of polled people in advance of this to see, what do people see as the next challenge, the next issue, the next problem in the near future. We talked a bit about, with respect to discovery, and, we talked about parallel proceedings in a different context. Where I think there's going to be a problem and where I think the task force is going to have to take up another issue is in the area of parallel proceedings, SEC, FINRA enforcement proceedings at the same time as arbitrations. Claimants counsel will always come to you and say, well, just give me everything that you've gotten or you've given to the government or to FINRA. And, was the burden. You already went through it, you already copied it, it's easy, put it on a disk, give it to me. Well, there are problems. Obviously, there's privacy problems because there's going to be information about other, non-claimants in there that you've got to sanitize. There's privilege issues. There's issues of proprietary information that FINRA or the SEC can get at, but the claimants ought not to get at. So there is a burden there. I have a colleague at the office that when I talked about this with him, he says, oh, no, I typically say, sure, I'll give you everything that I gave to the SEC relating to your claimant, and then hands them 2 pieces of paper or something like that. I mean, that's not helpful either in the sense that it just gets the fight further entrenched. But, that's something that I think is going to be a topic that we're going to see some discussion on in the near future. That's really all I've got. I just wanted to point out some of the things that have changed and put my 2 cents in on whether or not it's really met the goals that were set forth. I think in the end, I will say it has not, at least for the people in this room. If you go to the claimants bar, you may get a totally different answer. Thank you.